Hello, and welcome to The Right Side, the show where we take a look at today's news, views, trends, and opinions from a decidedly conservative perspective. I'm your host, Patrick Connelly, and we thank the Liberty Forum for sponsoring this program. I'm here today with our guests, Damien Schiff, Senior Attorney with the Pacific Legal Foundation. Welcome, Damien.
Thank you.
And we're also joined by John Cameron. He is the manager of the Pacific Legal Foundation's Liberty Society. Welcome, John.
Thank you very much.
It's great to have you guys here today with us in our studio. To begin, why don't you tell me a little bit about the work of the Pacific Legal Foundation and the Liberty Society there?
Well, Shane, as far as Pacific Legal Foundation itself goes, we were founded in 1973 by former members of then Governor Reagan's cabinet. And since the beginning, our focus has been on providing a voice for Americans who support strong protection of private property rights and other constitutional liberties in courts throughout the country. And our mission is to find cases, individuals who are beleaguered by state, local, federal agencies, to represent their interests in court pro bono, and to litigate cases to a high level, oftentimes to the U.S. Supreme Court, in order to establish significant precedents that not only can help our particular clients, but can help all Americans who find themselves in similar battles with government agencies.
Well, it's very important work that you're doing, and we appreciate it. And John, what does the Liberty Society do as part of that?
Well, my job as Liberty Society manager is to basically, I feed lawyers. It's a fundraising position. And we want to make sure that our talented, dedicated attorneys don't have to occupy themselves with making it rain. We make it rain for them. And my job as the Liberty Society manager is to treat our donors like the gold they are, because they're the ones that allow our attorneys to fight the fight. And typically, every time I watch one of the trials, we'll go in and our attorneys will be outnumbered 6-1 because the other side has our tax dollars to work with. So my job is to make sure that our donors, our supporters, who pay for that pro bono work, have the information they need to make informed choices. And that's pretty much it.
So with the kind of hours that are put in on these cases, especially if they go to higher courts, even to the Supreme Court, I'm sure that does take a lot of funding because it takes a lot of person time, billable hours, right, in the lawyer field. And so that money is very important. And speaking of that, now as senior attorney there, how do you make an impact directly at the foundation?
Well, a good part of what all the attorneys at PLF do is to find cases, either to bring from the beginning, filing a complaint in court, or to take over cases, say for an appeal, where a property owner has spent all of his or her litigation budget, no longer has the resources left to fight against a government agency. As John mentioned, typically government entities are represented by Attorney General offices or by the Department of Justice, so they have a very large litigation arsenal. An individual property owner or an individual citizen oftentimes doesn't have anything nearly like that. So we come in to help in those situations, and a lot of our work on a day-to-day basis is to find those cases that not only have a great legal issue, and in particular a great constitutional issue, but also a great story. The reality is that courts, particularly appellate courts, and in particular the Supreme Court, although they are courts of law, they are also sensitive to human interest stories. And so often, in my practice and in the practice of the attorneys at Pacific Legal Foundation generally, we've noticed that the courts are just much more likely to rule in your favor on the merits if they know that doing so is also the right thing. And so it's just critical for us to find that combination of a great case, great legal issue that will vindicate individual liberties, in the context of a great human interest story.
Right. Now, how long have you been with the foundation?
Since 2005.
And so what keeps you motivated? Is it fighting for the underdog? Is that the motivation? Good constitutional law? Is it all part of it?
All of the above, and I think John would say the same thing for individuals in our communications and fundraising departments, not just in our legal department, that being at Pacific Legal Foundation, you're part of a mission. You're trying to protect liberty in this country, and our particular part of that mission is in the courts of law, because so often you have either government that gets a lot of the breaks in litigation, or you have other public interest organizations on the other side of a lot of these issues, and they're very well funded and very well represented. But too often the beleaguered private property owner or the individual citizen who's told by a government agency that he can't do this on his property or that he can't speak this way at a public meeting, those are individuals who need help, who don't have the resources, and being able to help them to vindicate their liberties and also helping everyone else by establishing good precedents, that's really what motivates all of us to do this work on a daily basis.
And would you agree with that assessment?
Well, and I would, and I think what I'd like to tell you a little bit why I'm here. This is a late life labor of love for me. I've been with Pacific Legal Foundation for 3 years. I was very familiar with it because one of my best friends was a fundraiser for years. But a number of years ago, before I jumped out of airplanes and carried a machine gun for a living, I swore an oath. I said that I swear to protect and defend the Constitution of the United States against all enemies, foreign and domestic. And I really don't think that my father left his soul on Anzio Beach, and my mother's folks fought with the Swamp Fox during the Revolutionary War. And I think, I know that they would be appalled at what independent regulatory agencies do on a regular basis to be judge, jury, and executioner, to really crush the American people under the boot of the regulatory state. And so I'm fighting that same fight through raising money so that brilliant attorneys like Damien Schiff, sitting to my right, can fight for those freedoms. And it's important to me. And I think every single person in the organization has that same kind of, maybe not exactly my story, hopefully not, there's very few people in the building crazy enough to jump out of an airplane, but they all have that same kind of motivation. The attorneys could certainly make a much better living somewhere else, but they're driven by that patriotic fervor, that focus on individual rights, whether they're protected by the Constitution or just by natural law. And so that's why we're all there.
Well, excellent. Well, let's get into some of the meat of some of the cases, perhaps. I know that the Kelo decision was considered at the Supreme Court level maybe a low point in property rights. Where have we gone since then? What was the impact of that decision? And do you see any promising developments?
Well, frankly, Shane, it's kind of a mixed bag, frankly, since 2005. The Kelo decision, a 5-4 decision where the Supreme Court said that a government entity can take your private property and effectively give it to another private individual for the sake of redevelopment, and that is consistent with the requirement that private property shall not be taken for public use except upon payment of just compensation. But although that was, as you suggest, a low point, I think things are turning a little bit again on the Supreme Court, in part because of some of the more recent appointments to the Supreme Court. And we're hoping, in fact, right now, there is a case pending in the Supreme Court in which Pacific Legal Foundation represents a property owner called Nick versus Township of Scott, in which the property owner, Mrs. Nick, is contesting a local ordinance that says that she has to open up her private property for the public to inspect to try and find ancient gravestones in eastern Pennsylvania. She argues that that's a taking of her private property without just compensation. We've been trying to get an issue like that up to the Supreme Court for the last 15, 20 years. The Supreme Court last year agreed to take the case. It's been argued by my colleague Dave Bremer at Pacific Legal Foundation twice. We're expecting a decision any day now. I think how the Supreme Court rules on that will probably tell us a lot about where property rights are going for the next 5 to 10 years on the Supreme Court, because it'll be the first major property rights case the Supreme Court has addressed since the retirement of Justice Kennedy and the appointment of Justice Kavanaugh. And I want to really highlight that for the viewers, because some may not realize that the critical vote, or one of the critical votes, in the Kelo case was from Justice Kennedy. And although oftentimes Justice Kennedy was a supporter of private property rights, I think it's fair to say that he wasn't always as zealously in favor as some of his colleagues on that court. Now, this is an opportunity to see if his former law clerk, now Justice Kavanaugh, whether he might move the property rights needle, so to speak, a little more to the property rights side. And that's a decision, as I say, the Nick case that could come out any day now. And I think that's really an important one to focus on to help us predict how will the Supreme Court address property rights over the next generation.
Now, when you're making the arguments, we have this traditional split on the court in recent years anyway, 5-4 decisions with sometimes swing vote. Are you appealing to the court as a whole or to a faction of the court? You've argued before the court before yourself, right?
Yes, I have. And, it really depends upon the issue. Notwithstanding the extreme polarization that you sometimes find on the Supreme Court, there are still sometimes issues where you can even obtain unanimity on a case where you're ultimately vindicating private property rights. Pacific Legal Foundations, of the 12 or so cases that we've had in the Supreme Court, several of them have been wins and several of them have been unanimous wins. And in fact, just in November of this past year, we were parties to a case in the U.S. Supreme Court concerning critical habitat in the Endangered Species Act and the extent to which the federal government can limit private property rights in the name of endangered species conservation. That was a case where we represented the property owner, litigated the case with other property owners in the Supreme Court, and the Supreme Court ruled 8-0 in this past November in favor of the private property owners. And so that's just one example. We have other cases where you have 8-0, 9-0 rulings where even the liberal side of the court is willing to say enough is enough, that individuals have the right to judicial review, that to some extent administrative agencies have to be limited in their discretion. And so there are opportunities where you can find that unanimity. Now, not always, and we've also won some cases by the skin of our teeth, so to speak, 5-4, but I think that recognizing that even on the court today you can find unanimity in a pro-liberty framework is encouraging.
And do you find that in your work in development and fundraising that you're able to reach out to some folks that you traditionally not be supportive of a conservative organization, but may find common ground on some liberty, issues of liberty when liberty is at stake or when progress is thwarted by a restriction of liberty?
Well, I think you hit the nail on the head. We have, like any other organization, we have people who are, one issue or two issue donors or supporters. We have other people who are simply just great fans of that. One of our donors said that it's amazing that this country was created out of whole cloth on 4 large sheets of paper. And we have an awful lot of fans of that document that's getting a lot of bad press now, called the Constitution. And we are passionate supporters of that document. So really, any part of it that we support, our donors will follow us. Some of them, the state of California is such a horrible place to try to get anything done from a business perspective that a lot of our donors do come from California. But I don't think, other than the Nolan case, how many of our Supreme Court cases have come outside the state of California?
I would say at least 8 or 9.
Yeah.
At least 8 or 9.
So even though it says Pacific Legal Foundation, and we started in Sacramento, California, our reach is national, and we have even international donors. We have a lot of people who've chosen to live elsewhere for various reasons. Tax purposes might be one of them. Many people who moved out of the state of California, but their love for the Golden State and their horror about what's being done to it by these overzealous regulatory agencies, keeps them supporting us. So we have single issue supporters, and we have people who are just great fans of the fact that whether individual liberty is spelled out specifically in the Constitution or is just part of natural law, they understand that where individuals are more freer to go about their business, the world as a whole is a better place, and those individuals are better off as well.
No, I think of things like the California Environmental Quality Act, also things like project labor agreements that make things, that restrict people's ability to get things done in California, and also make them incredibly expensive along the way. Are we seeing abuses that you're able to challenge on a legal basis? We had the victory for free speech with the decision that freed union members from having to pay mandatory dues. But we have other restrictions. Talk a little bit about any of those areas that you're working in to ensure that outside of property rights, that our other rights are respected.
Well, you alluded to the Janus decision from the Supreme Court that held that that public employees can't be forced to support the union evangelistic activities of public sector unions. And perhaps not surprisingly, California is trying to respond to that decision in a way to undercut it. And so I'm quite confident that Pacific Legal Foundation is going to be policing those efforts to make sure that the California legislature or other state legislatures don't try and undo that very good decision. But as far as the California Environmental Quality Act goes, unfortunately, the way that law has developed, it really no longer even serves the original purposes of ensuring that significant public projects take into account environmental impacts. That seems like a pretty plausible, reasonable idea. But almost from the get-go, the courts interpreted that law in a very peculiar way. Originally, it wasn't really intended to apply to private activity. They just needed a permit. But the Supreme Court, the California Supreme Court, only a few years after SEQ was enacted, said no, it applies not just to public projects, but to private projects as well. And that gave birth to a whole industry of litigation where you have private groups who essentially don't want development for a variety of reasons and use CEQA as a tool either to make development more expensive or to make it so expensive that no development happens. The courts, by and large, haven't really stopped that, and so at this point, if the people of California want an improvement to CEQA, it really has to be through legislative change. With public labor agreements and the union issues, it's a little easier to obtain some relief from the courts because they've recognized that there are First Amendment values going on here, the Janus case being the most prominent one. But right now, Pacific Legal Foundation has a case that we're hoping the Supreme Court will take up that comes out of California concerning project labor agreements, and in particular, the process by which California has a prevailing wage credit system. The prevailing wage is this wage that you have to pay for employees who work on public projects. Perhaps not surprisingly, the prevailing wage is substantially higher than what the market rate would be. However, a public contractor can obtain credits for this prevailing wage credit by a variety of means, and one of the means that the legislature used to allow was that a contractor could make a donation, and that donation would be a credit against his obligation to make a prevailing wage payment. And that credit could go to what's called an industry advancement fund. And there are industry advancement funds that support the industry, the construction industry, from a union perspective. And there are industry advancement funds that support the industry from an open shop perspective.
Are these like training funds or programs to do outreach and things?
Exactly.
Like that?
And from the perspective of the industry advancement funds that are in support of open shops, a lot of what they do is support advocacy showing that project labor agreements and the prevailing wage requirement oftentimes add significant costs to public projects like the construction of school buildings or what have you.
Well, in the city of San Jose, right here in Silicon Valley, I think in the last 2 years, the prevailing wage increased around 36%. Mm-hmm. So it's accelerated costs mightily around public projects in the city.
Without necessarily any real benefit to the taxpayer because of that increased cost.
Yeah, we're just getting less of whatever it was, whether it's paving streets or affordable housing for the unhoused.
And it's those injustices that these industry advancement funds were highlighting. Well, surprise, surprise, the unions in this state and the legislature didn't like that. So they decided, we're going to change the law so that you can no longer get a credit if you make a donation to one of those groups. You only get a credit if you make a donation to a group that supports unions. And our argument is that that basically is a First Amendment violation because the government is trying to penalize individuals for supporting certain viewpoints. And unfortunately, the Ninth Circuit Court of Appeals ruled against us, but as I mentioned earlier, we have our petition pending right now in the Supreme Court, and we may know by the end of this month whether the court will take it up. And so we certainly hope so, because it really is unfortunate how in this state not only is union labor and not only are public projects making things worse for the taxpayer, but now the state's also even preventing citizens from effectively speaking about how this system is unjust and how the system is ineffective.
So really taking away people's voices. And
Absolutely.
That's why your work is so very important, to have those voices in the discussion at all times. You talked a little bit about CEQA. Have you done any work on cases related to CEQA?
Yes, principally, more recently, what we've done is filed friend of the court briefs, and that's an aspect of our litigation that is important because we don't always just get involved in cases directly representing parties. Oftentimes, what we'll do is we'll submit a brief just on behalf of the foundation itself, where we explain to the court what we think is the appropriate resolution of the legal issue at hand. And we find that even when we can't get directly involved in a case, filing that kind of an amicus brief can be very helpful. And we filed briefs recently in CEQA cases concerning the extent to which CEQA applies to the initiative process or to the referendum process, the extent to which CEQA provides an exemption for the construction of single-family homes. As you can imagine, given how burdensome CEQA is, the exemptions that the statute allows have become all the more important. But not surprisingly, those who like to use CEQA for improper ends want the courts to interpret those exceptions very narrowly. And one of the most relied upon exceptions is the single-family home exception. So there's been a lot of litigation over the extent to which one can avoid CEQA altogether because one's just building a single-family home, or whether that exception doesn't even apply. And so we've also filed briefs on that issue as well. But again, the problem with CEQA really is that the state courts have said, we think the law is not that great, but we're going to apply it as we think it's written. We're going to give it to the legislature to try and fix things. So we have to hope that maybe with a new administration, perhaps there may be some change, but if not, we'll have to think of other maybe constitutional ways of improving things.
Yeah, and that's definitely one of those issues that cuts across traditional political boundaries. There's Jennifer Hernandez out of Berkeley, who's an attorney in land use and was one of the proponents, I believe, for the California Environmental Quality Act when in its inception, and now sees that it's highly abused. And so, yeah, I guess that's a legislative fix that we'll need to look to, and a little outside the realm of what the foundation's doing. But what do you see coming up on your calendar as other cases? You mentioned a couple that you're working on, one currently at court and one you're hoping to get there.
Yes.
Are there others in the pipeline?
Certainly, and I should say, right now we have probably over 100 cases of both representing individual parties as well as filing amicus briefs. One case we have going on right now in the California Court of Appeal concerns the California Coastal Commission, which is a statewide agency that if you have property along the coast, you definitely know about the Coastal Commission. You also know that the Coastal Commission can be a very belligerent agency. Right now, we represent on appeal a husband and wife couple who own a home along the beach in Malibu. They were fined by the Coastal Commission over $4 million because when they bought the house, there were a stairway, a gate, a few planter boxes, and a fence that they later were told by the commission were obstructing a public access easement. Our clients, the Lent family, said, now wait a second, we think in good faith that no, these are permitted structures. Not only did the commission disagree, but the commission used its new power that the legislature granted a few years ago to issue what's called an administrative penalty order. This is a penalty order that becomes immediately effective once the agency itself issues it, without any prior judicial review or check, and without anything even approaching a trial in the agency before it's issued. So our clients, the Lent family, were fined, as I said, over $4 million, immediately effective. They had no trial. They had no opportunity to cross-examine witnesses.
So lack of due process.
There was absolutely no due process. And what makes it even worse is guess where the funds go from these administrative penalty orders?
I have no idea.
They go into what's called a violation remediation account, which the commission itself, by and large, dictates how that money is spent.
Oh.
So now you have the Coast Commission as an agency both adjudicating wrongdoing and then directly profiting in furthering its own interests by taking the proceeds of those penalty adjudications for its own purposes. So we think that this case raises a big constitutional problem for the Commission. We're in the Court of Appeal right now, and we're hoping for a good result in that case. If not in the California courts, and ultimately we hope maybe even the U.S. Supreme Court.
Oh, very good. That's a very important case, it sounds like. So we're glad that you're working on that and protecting our interests here in California. Are there any just final thoughts that you would like to share, maybe John, about
just to show you how ridiculous that case is very quickly. The California Coastal Commission wanted the Lents to remove a barrier to beach access, and they wanted the barrier there because there was a somewhere between 9 and 20-foot drop onto a drainage that went to the ocean if they were to move the gate out of the way. And that was one of the main costs or the main reasons. They said, you're blocking public access. So they removed the gate. Another state agency put a gate back up in exactly the same place because it was a danger to the public. But the Lents are still facing the $4 million fine. So that's how ridiculous the California Coastal Commission has gotten. They are the poster child for regulatory overreach and unconstitutional takings, and that's why we're constantly in court with them.
Well, John and Damien, thank you very much for joining us today. Our show is quickly approaching an end, but the people at the Liberty Forum will get to hear a lot more from both of you later, and we're excited about that. And please join the Liberty Forum on the second Tuesday of each month at IFES Hall, 432 Sterlin Road in Mountain View. In July, they will have Kathy Platani, the first-hand witness to the 2009 Fort Hood shooting. In August, Andrew McCarthy, a columnist for the National Review, will be joining them. And in September, Kay James, the president of the Heritage Foundation, one of the most influential conservative think tanks in the United States, will be joining the Liberty Forum. Thank you for joining us here today on The Right Side, and have a great day.